take a chance on me. United we will be. You gave me a reason to fight once again. We stand together, we'll stand till the end. Through all the pain, I know this is worth dying for. We are the sword. As one blood we will fight, and we will make it out. Frozen better, we will battle till the glory sun will rise. We are the sword.
War.
Alone we're just as one, but unified with your light, we can shine in the dark. You gave me a reason to fight for the truth, not just for us, but for others abused. We will defend the defenseless as the rain pours. We are the sword. As one blood we will fight, and we will make it out. Frozen better, we will battle till the glory sun will rise. We are the sword.
War.
Gave me a reason to fight once again. We're on the front line, still marching ahead.
Love.
Gave me a reason to survive anyway. You gave us a reason to fight.
War.
Hello, everyone. Welcome to Procedurally Barred, where we discuss the Avery case and the Dassey case, as well as many other aspects with what's wrong with our criminal justice system. I'm Obi, and as with me, as always, is my confidant, Emma J.
Hi there.
Today, we thought we would get more into the legal aspect side of the case. This podcast is mainly directed to those who are a little newer to the case, as we get a lot of new people in here, like on a daily basis. People wanting to get themselves involved, wanting to weigh in on the case, give their take, share their views and opinions, as well as helping the Stephen Avery and Brennan Dassey community spread awareness about what's wrong with today's system. I also want to take a second to discuss something that's been going on in the community that's creating a lot of issues. We are supporters. We are not always going to agree with each other's opinions and views. We might not share in them. What one person might believe is what happened. Another person may have an entirely different outlook on the case. No one has the answer to this case. We share information, theories, ideas, and collaborate with one another to make sense of this case. We are here to be supportive of the case and to be supportive of each other. There is no reason to target and attack another supporter just because they believe in something you don't. I have seen this division damage this community long enough and chose to fight back and correct it. We have a right. We have many rights, just as we do in our personal lives in the real world. just as we do on social media. We have the right to freedom of speech. We have the right to freely express our opinions and views publicly without being infringed upon, attacked, targeted, silenced. We have a right to freedom of press. We should be coming together as a community and supporting one another as well as apart from this case. Support each other, respect each other's opinions and views. No one should have to feel threatened because they wish to share their beliefs openly on a public forum. Be kind with one another, support one another. We're not here for drama. We're not here for fighting. We do nothing good by fighting. This has done nothing but damage the community. It doesn't help bringing the boys home. All I ask is to please bring peace, not hate. Thank you.
Well said. Right. I thought we could start off here with asking, did the state of Wisconsin or its public officials violate the rules of law as it pertains to both Brady and Denny, but Youngblood also? Did the state of Wisconsin or its public officials who represent the state of Wisconsin violate Stephen Avery's rights prior to, during, and post-trial? What do you think there, Ben?
I believe they did. What this podcast is mainly about is about the German. A lot of people have heard of this, which they think is a theory, but it is actually really what happened back in the week of Teresa going missing. To understand this newly revised rendition of a theory, we first need to understand the importance of a defendant's right that plays in today's judicial system. Just as those rights existed back then in 2005, as they do now. With the exception of judicial reform, and most reform brought on change due to Stephen Avery's 1985 wrongful conviction, it should have been taken into consideration, but merely was discarded and overlooked by law enforcement and the judiciary. Understanding this, you'll need to know the differences between Brady, Denny, Youngblood, and a few other rules of law. We also dive into our rights as human beings, our civil rights as an American, and more importantly, what rights you may have if you find yourself on the wrong side of the law. As a defendant or a suspect who's being charged with a serious crime, or like such as murder and I mean other forms of crimes, but just because they're suspected of a crime or charged criminally, they, as a human being, still have rights. And those rights are what we're looking into discussing today.
Because the theory of the German has been floated around. It's raised its head a couple of times and sunk back down again. And I don't think anybody's done what we have regarding the German. It's never been looked at in the way that we've looked at it, and not as extensively as we've looked at it. But in order to understand the implications of what happened with that person, you need to understand the thought behind Brady, Denny, and also Youngblood. So we're looking at that first before we get to the juicy stuff, I think.
Yeah, these rights and laws, I mean, they definitely play a significant role. I mean, they're definitely in Avery's case here, because they were definitely violated several times over.
Yeah, and I think previously anyone who's looked at the German has looked at it as a sort of freestanding theory. They haven't looked at what that theory means for Stephen Avery and what it meant at the time of his trial. So I think that starting out with this, it shows you, once you hear more about the German, you understand what the implications are of his story and the effect it has on Stephen and Brendan.
Right.
You ready for the next slide?
Mm-hmm. Go
Okay.
ahead.
Well, Brady violation, that's the bit that you've been looking at, because I've been doing the Youngblood.
All right, you want me to get into it?
Yeah, Brady's yours.
All right. The suppression by the prosecutor of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or punishment. Brady consists of exculpatory or impeaching information and evidence that is material to the guilt or innocence or to the punishment of a defendant. The term comes from a 1963 United States Supreme Court case, Brady versus Maryland, in which the Supreme Court ruled that suppression by the prosecution of the evidence favorable to the defendant who has requested it violates due process.
Okay. And so what does that mean in terms of how it affects a defendant?
All right, say the any public official. I mean, it doesn't really just this just isn't for prosecutors. Every law enforcement official or public official, whether in the court system, district attorney's office, they all have, or the DOJ, they all have to follow this standard. If they have information that is exculpatory to a specific individual who is on trial and charged with a crime and is getting ready to be prosecuted, if there is information available that's exculpatory that could either exculpate or inculpate a defendant, they are to be forthcoming and disclose that information to the opposing side, which is the defense.
Okay, so it means that the prosecution have to give the defense evidence that they have that could help the defense.
Yes, favorable.
Okay.
If that information shows that a defendant is actually innocent of the crime he's being charged with, they are by law to hand over such evidence if it exists. And
Okay.
I believe that the person responsible to, like, if the prosecution has such evidence, they're to notify somebody higher than them. I think that the party that is supposed to be given this information, first off, is the Attorney General. Or, not the Attorney General, maybe not. Maybe it's the Inspector General. But the information is supposed to be given to the defense, obviously, because they have a right to know. if there is any evidence out there that exists to help them in their case to successfully adequately defend themselves, they should be given that information.
Yes.
But to get further into Brady, Brady is a doctrine. It is a pretrial discovery rule that was established by the United States Supreme Court. Brady versus Maryland, 1963. The rule requires that the prosecution must turn over all exculpatory evidence to the defendant in a criminal case. Exculpatory evidence is evidence that might exonerate the defendant. Examples including the following: the prosecutor must disclose an agreement to not to prosecute a witness in exchange for the witness's testimony. 2, the prosecutor must disclose latency or preferential treatment agreements made with the witness in exchange for testimony. 3, the prosecutor must disclose exculpatory evidence known only to the police. That is, the prosecutor has a duty to reach out to the police and establish regular procedures by which the police inform a prosecutor or prosecutor's office of any that tends to prove the innocence of the defendant. 5, or not 5, not all exculpatory evidence is required to be disclosed by Brady and its progeny. Only evidence that is probable of changing the outcome of the proceeding. The prosecutor is not obligated to personally review police files in search of exculpatory information when the defendant asks for it, but to allow the defense reasonable access. The Supreme Court observed in Strickler versus Green, thus the term Brady violation is sometimes used to refer to any breach of the brand or broad obligations disclosed exculpatory evidence, that is, to any suppression of the so-called Brady material. Although strictly speaking, there is never a real Brady violation unless the non-disclosure was so serious that there is a reasonable probability that the suppressed evidence would have produced a different verdict. The prosecutor must disclose arrest photographs of the defendant when those photos do not match the victim's description. Some state systems have expansively defined Brady material to include many other items, including, for example, many documents such as that may reflect negativity on the witness credibility. Police officers who have a dishonest or sometimes referred to as Brady cops because of the Brady ruling, prosecutors are required to notify defendants and their attorneys whenever the law enforcement officials involved in their case has substantiated record for knowingly lying in an official capacity. The growing use of Brady both in the federal and state sectors is one of the most important changes affecting police officers and employment. Brady disclosure consists of exculpatory or impeaching information and the evidence that is material with guilt or innocence juror to be punishment of a defendant. In which the Supreme Court. Oh, sorry. Go ahead.
Well, following Brady, I think the prosecutor must disclose evidence or information that would prove the innocence of the defendant or would enable the defence to more effectively impeach the credibility of a government witness. Is that right?
Yes. Yep.
Okay. And the evidence would serve to reduce the defendant's sentence must also be disclosed by the prosecution. In practice, this doctrine has often proved difficult to enforce. Some states have established their own laws to try and strengthen enforcement against prosecutorial misconduct. So basically, in a nutshell, it's Brady means anything that could show the innocence of the defendant has to be disclosed.
Correct.
Okay.
The procedures for compliance. In order to ensure compliance with Brady, the United States Supreme Court repeatedly urged prosecutors to favor disclosure over concealment. Conformity with Brady is a continuing obligation of prosecutors. Some prosecuting attorneys have adopted and created specialized procedures in boroughs to meet their burden. Pitchess versus Supreme Court. It is the source for a pitchless motion. In California, such as a motion can be made by a criminal defendant to discover complaints made against a police officer and an investigator of those complaints, such as they are contained in the officer's personal records. Motions can be made in California Supreme Court under California Evidence Code 1043, 1046. However, it is notwithstanding because of the broad nature of discovery that the associated court rule and statute provide, getting actual records can be complicated. In California, there is carefully prescribed procedures governing these requests, and making disclosure without an order is a crime. The statutory scheme was developed in part because the law enforcement departments had developed a practice of perjuring their files concerning misconduct claims against their own officers.
Okay. You ready to move on to Youngblood?
Yes.
Okay. Okay, a Youngblood violation occurs when biological evidence collected in a case against the defendant, such as blood or any other biological sample, is not stored correctly. Evidence containing biological specimens should be kept sealed and refrigerated in order to preserve the sample for future testing. The Supreme Court held that a criminal defendant must show bad faith or malicious intent on the part of the police to prove that the loss or destruction of evidence was a denial of due process. So what this means is when samples are taken, they need to be stored correctly. Many samples are kept for future testing because current tests are not sophisticated enough to give a result. But as new tests are developed, evidence that was previously unable to give an accurate test result can be tested again, but only if the evidence was stored correctly. If evidence was known to have biological evidentiary value and was destroyed by not being kept properly, then a Brady violation could have occurred. The Supreme Court held that a criminal defendant must show bad faith or malicious intent on part of the police to prove the loss or destruction of evidence was a denial due to process, as in case law Arizona versus Youngblood. So a quick synopsis of Youngblood versus Arizona. An individual convicted of child molestation challenged his conviction based on the state's failure to preserve certain evidence. Unless a criminal defendant can show bad faith, then it doesn't constitute a Brady violation. So Larry Youngblood was convicted by a jury in Arizona of child molestation, sexual assault, and kidnapping. The Arizona Court of Appeals reversed the respondent's conviction because the state did not preserve certain semen samples. The respondent's principal defense at trial was that the boy erred in identifying him as the perpetrator of the crime. Both a criminologist for the state and an expert witness for the respondent testified as to what might have been shown by tests performed on the samples shortly after they were gathered, or by later tests performed on the samples from the boy's clothing, had the clothing been properly refrigerated. The court instructed the jury that if they found the state had destroyed or lost evidence, then they might infer that the true fact is against the state's interest. The Court of Appeals reversed the jury and found when identity is an issue at trial, the police permit the destruction of evidence that could eliminate the defendant as the perpetrator. Such loss is material to the defence and is a denial of due process. Further, the court concluded, without implying any bad faith on the part of the defence, that on the basis of the expert testimony at trial, that timely performance of tests with properly preserved semen samples could have produced results that might have completely exonerated the respondent. So does the United States Constitution require the state to preserve evidentiary material that may be useful to a criminal defendant? The answer to that is no. The majority first observed that this case required them to address what might loosely be called the area of constitutionally guaranteed access to evidence. Pursuant to Brady versus Maryland, the court observed that in the past it held the suppression of the prosecution of evidence favourable to the accused upon request violates the due process where the evidence is material either to guilt or to punishment, irrespective of the good or bad faith of the prosecution. Further, based on United States versus Argas, the court observed that it had been held the prosecution had a duty to disclose some evidence of this description, even though no requests were made for it. But at the same time, we rejected the notion that a prosecutor has a constitutional duty routinely to deliver his entire file to the defence counsel. Based on the facts of this case, the majority held that the police did not violate Brady or Argas. The state disclosed relevant police reports to the respondent, which contained information about the existence of the swab and the clothing, and the boy's examination at the hospital. The state provided respondent's experts with the laboratory reports and notes prepared by the police criminologist, and the respondent's expert had access to the swab and the clothing. Unless a criminal defendant can show bad faith on the part of the police, failure to preserve potentially useful evidence does not constitute a denial of due process law. In this case, the police collected the rectal swab and clothing on the night of the crime. The respondent was not taken into custody until 6 weeks later. The failure of the police to refrigerate the clothing and to perform tests on the semen samples can at worst be described as negligent. The court would have disagreed with the Arizona Court of Appeals if they had held that the due process clause is violated when the police fail to use a particular investigatory tool. So this, in a nutshell, means if the police have evidence that's biological in nature, it has to be properly stored. And if it's not, and you can prove that there was bad faith or malicious intent, that is a Youngblood violation.
Can you give any examples as to this Youngblood, comparing this to Stephen Avery's case, as to what evidence was not properly obtained? Or
it relates. My understanding is there's a bit of a crossover between a Brady violation and a Youngblood violation, with the bones being given back to the family. In 2005, the DNA testing was not as sophisticated as it is now. And the testing that we have now could have yielded a much better result than the tests they had back in 2005. So if they still had the bones, Zellner wanted to get hold of the pelvic bone for it to have the new anti-rapid DNA testing. The fact that they have not kept the bones, that's as well as being a Brady violation, that may also be a Youngblood violation as well, because they haven't been stored in a manner that allows them to be tested now.
You know, I keep thinking about back when they collected, well, claimed that they had collected all these bones. We see all these bones in a box, and they lied to not only the public and through the media, trying to claim that these bones were identified and verified as belonging to Teresa. And in fact, that wasn't even the case. And
No.
one would think that just because they tested one bone and that it came back as being what, like 7 loci?
Yeah, it was 7 loci, and it was less than half of the required ones. I think the end of the FBI report just simply said they couldn't rule Teresa out. That's not saying that it is her. It's not saying that it's not. But it's more to do, I think, with keeping hold of biological samples and storing them correctly. Now, the reason why this is relevant in the case of the German is that there is biological evidence in existence, and we don't know if it's been stored correctly or if it's just been left in a bag in the evidence room. The big point here is that there is biological evidence that will either show that it was him or that it wasn't. This evidence has never been tested, and we don't know if it is still there and still safe, and if it's been stored in the way that it should have been. So this is where the Youngblood violation comes in. You're all going to hear more about what this evidence is, but the reason why this is important is because we can prove bad faith and malicious intent with how this evidence was managed. So we've got the bad faith, we've got the malicious intent on the part of the police. We just need to look at what the evidence is, what the biological sample is, and the big question is, has it been stored correctly or not?
You know, not only was some of this evidence, you know, what's kind of crazy is that there's record and there's evidence existing that law enforcement did in fact collect evidence off of the German's wife.
There's
But
a very clear paper trail.
they also entered some of this evidence in Avery's case, but other pieces of evidence, you don't see them in Avery's case. They only like picked and choose what they wanted to submit in as evidence or collect as evidence in Avery's case, which is kind of, I don't know, it's kind of it's really suspicious, you know.
There's a lot of suspicious activity going on with that evidence, because we have the German's wife story of what she gave in and what the paperwork shows, and they are two very different things.
And we're not talking about just any police department. Manitowoc County Sheriff's Office had collected evidence, and they knew that they had this evidence prior to Avery's trial. And not only did they know, but a prosecuting attorney also knew of its existence that was linked to Stephen Avery.
Yes. So what we get from this is we know that there's definitely been provable Brady violations. The more we get into the case, the more people will see the Brady violations that have taken place. With the Youngblood violations, it's a bit more grey, because we don't know if the samples have been stored correctly or not. If they have been, there is no Youngblood violation taken place. So straight away, any Youngblood violations are off the table. The answer is we don't know, because we know those items went into evidence, but we know nothing more. And this is where it's going to get fun. Are you ready for the next slide?
Not really, but I'm all right.
Is there anything else you want to add there?
No, we can continue.
This is the fun one. Ben,
when you want to talk about certain things, you just have to hold back, because it comes, you know what I mean, it comes in later in the story. And if we discuss it and bring it out now, it kind of like would ruin things. But I mean,
but it's so hard not to.
I know it is.
The implications of what you're going to hear in the next presentation, once you've got this background, you will understand a lot more the significance of what is about to come. That's why we've done it the way we have. We want to have everybody understanding all of the German case and what it means for the Stephen and Brendan cases.
Yes, so everybody needs to be brought up on par with the legal aspect side of the case before understanding what they're about to hear.
Yeah, because otherwise it's just another theory, it's just another story. You need to understand what it means. So Ben, what is a Denny?
A Denny is a double standard that is often up. Hold on a minute. I'm sorry.
Because we don't have Denny here. I'm based in Wales. We don't have Denny. So I've got, my knowledge is very limited. So Ben, what is a Denny?
Under Denny, a defendant be required to demonstrate a legitimate tendency test in order to suggest third-party liability. The defendant has to show motive, opportunity, and some evidence to directly connect to a third person to a crime. The Denny rule is a bizarre double standard that often operates to shut down a third-party defense that might be brought by a defendant. It does not, or it does this by placing a much higher evidentiary burden on defendants than on the state.
Okay, so from this, it means that in order to say, listen, it wasn't me, it was someone else, you have to show that that someone else has got motive, which is a reason to do it. They had the opportunity, and there needs to be some evidence to link them to the crime scene.
Yes, it's kind of crazy because the state doesn't have to provide these three requirements. It's only a defense. A defense if they're suggesting Denny or wanting to use Denny in trial as a defense, they have to come up with motive, means, and opportunity.
So the prosecution, they don't have to show that Stephen Avery had motive, opportunity, or evidence. The prosecution haven't got to prove that. But
No.
that if the defense want to say it wasn't Stephen, we think that it was someone else, then the defense have to prove the motive, opportunity, and links to the crime scene.
And I have a really, really big issue with the way Denny was handled in Avery's case, because I believe that this is a right for Stephen Avery. I believe that if Stephen Avery wanted to use Denny at trial, that is his right. And he is supposed to have every tool available at his disposal to adequately defend himself at trial. And this is one of these tools, you know? And I believe that he was deprived of this in some manner, because I don't believe that a judge has a right to weigh on whether Denny is to be used for a defendant at trial. I don't think that right belongs to him. If any one of us could look at this case right now, and we could look at many suspects in this case, and we could argue and we could establish many different motives, opportunity, and means for multiple people, and the story we get is that Dean Strang and Jerry Buting argued and lost. They lost this. They had a Denny list, though the German wasn't on that list, but they had many other suspects on there, which many people could have established these three requirements to establish Denny.
Yeah.
And I cannot see how they could lose this right. I don't see it. And I don't understand how a judge has a right to make a decision. And granted, what I think happened is that the prosecutor's side and the opposing side, the defense, they were making agreements. There's the gentleman's agreement, and this gentleman's agreement, I believe, is unbeknownst to Stephen Avery prior to trial, or at trial, during trial, because these gentlemen's agreements, they would have been wagered and argued prior to trial. You know what I mean? So what happens is you have discovery. You know what I mean? Both opposing sides get the chance of discovery for each opposing side, and they know what they're up against prior to going into trial. And this is where you put your cards on the table and you speak amongst each other and choose whether to submit in as evidence at trial and what not to submit in as evidence at trial. If the prosecution doesn't like something, he has a chance to argue and fight to either suppress it or keep it out of trial. Uh, and also on the part of the defense, you know what I mean? And then the judge hears the argument, and if both parties can mutually agree upon a certain aspect or a certain decision, the judge will grant it. But the judge himself has no bearing on what is to be brought in or what is not to be brought in. That's for them to argue and decide amongst each other. He's just basically the mediator, you know. Uh, and I believe that if they wanted Denny at trial, they would have had it.
Yeah.
The only reason why Denny wasn't able to be used is because the prosecution and the judge and the defense mutually agreed upon leaving it out. And later
Yeah.
on, a I have an argument to support that, you know, but I'll hold off. And that argument is basically Ken Kratz's closing. The 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 narrative that Ken Kratz had suggested to the jury by misleading them as to what the defense's case was suggests the reasons as to why they decided to keep Denny out of trial. But I mean, we can continue if you have anything else to add.
No, we're good.
No.
We're good with that. Okay, so next we're looking at the presumption of innocence. A defendant is to have the presumption of innocence heading or going into a trial and to be looked upon as being presumed innocent until proven guilty in a court of law. Defendants have several constitutional rights. Just because they are charged with a crime doesn't mean they are unworthy of these rights. Rights are in place to protect United States citizens. These rights cover the right to Miranda, which includes the right to remain silent, the right to legal counsel during questioning and interrogations, the right to have any questioning or interrogation recorded, the right to confront witnesses within the legal process and proceeding setting, the right to have a fair and public trial, the right to a jury trial, the right to a speedy trial, the right to legal counsel, attorney, or legal representation, the right to receive adequate representation, the right not to be tried for the same crime twice, otherwise known as double jeopardy, the right to the preservation of any and all potentially exculpatory evidence and information, including biological material, and the right to any and all exculpatory information that may be favourable to the defence or a defendant, or evidence that may be used to include or exculpate a defendant from the crime in which she was charged of or shown to be innocent of committing. Ben, do you want to help me with this one?
What's that?
Well, there's quite a lot there as the rights under law, and being from the UK, I don't understand that so much, but from what I can see and from the research that I've done, there was several things here. The presumption of innocence, to me, that ended for Stephen when Kratz gave his little squeaky voiced conference about all the terrible things that Stephen and Brendan had done to Teresa.
Yeah, he was talking about several other things too. I mean, he was talking about Stephen Avery's past, bringing up things which, I mean, a lot of things are very questionable. I mean, we're not going to say that Stephen Avery was a saint and he never got himself in any kind of trouble. I mean, the things that he has done, he's owned. But I mean, he definitely. I mean, it was like trial by media. You know, they used the media to basically produce this um, image, you know, of Stephen Avery, and they used his past against him, and he was basically guilty long before trial even began, you know. And
Well,
the thing is you're supposed to be innocent until proven guilty, but in fact you're guilty until you can prove yourself innocent, and that's not the way that the criminal justice system is to work.
yeah.
We are we have a right to be presumed innocent, and the state has the burden to prove their case, you know.
Well, you could say even Stephen lost that presumption before Kratz and his little media circle.
Yes.
You know, you could even draw it back even further to, do we have Avery in custody yet?
Mm-hmm.
You could draw it back to there. They thought it was him straight away. They've never looked at or investigated anybody else. It was only ever Stephen, and anything that drew them away from Stephen was very quickly covered.
What's kind of crazy is that I remember certain things that were being relayed through the media, and the media is that they claimed that police were looking into other suspects, and you don't see that. You don't see that. They may have spoken with, I mean, other members of the family and friends, but they didn't look for other suspects. They
No,
didn't.
they didn't concentrate on anyone else the way they did on him. They went up to sort of anyone that they spoke to. It was very along the lines of, was it you? No, it wasn't me. Okay, fair enough. We've investigated you.
And a lot of these witnesses that had come forward, you know, and uh, being forthcoming with information and trying to help out and do the right thing to figure this out, they're relaying information, and there was many leads and many witnesses have come forward, and they wouldn't even have followed up on him until like a year later down the road.
Mm.
Like, how do you not follow up on a witness until a year later?
Well, it's that same news story back from the 1985 rape case when that was all straightened out, and one of the papers carried the line, Avery zeroed in on quickly, and that's exactly what they've done the second time. But we know there was quite a lot of his rights that have been broken here. It says you have a right to a fair trial. Do you think that Stephen Avery received a fair trial?
No, definitely I did not.
No, I think I think Making a Murderer put that across really well. And then you've got
They ruined any chance at a fair trial in that press conference and long
yeah.
before that press conference. They ruined any chance for him to even possibly have a fair trial in another venue. That's why, I mean,
Mm.
there was the change of venue, but what good was it going to do?
It wasn't going to do much good when you're bringing the judge from the
Right,
last place and shipping in the jury from there as well. All you've essentially done is change the building to make it look
r-
nicer on the video. It's
right,
it didn't achieve much towards giving him a fair trial. And there was so much that was held back that the defence weren't allowed to talk about, which is now all of this is what is allowing Zellner to bring the ineffective counsel into the latest appeal,
right.
which is then when we get on to the right to receive adequate representation. Now, for me as well, I don't think Brendan received that either.
No, definitely not.
You know, when you've got people like Kaczynski, who were meant to be defending Brendan, who very obviously didn't. So there's lots of constitutional violations here.
Yeah, like Len Kaczynski. Well, like he's there to defend his client, and he's there to fight for him, and they're not there to make a decision on whether he's guilty or not. He's there to fight for him and to defend. Yeah, I mean, obviously defend him and to get him out. And instead, he is working against him. He's working for the state, and he's doing what law enforcement should have done. But he's the one that's basically, well, I mean, they both did the same thing, Len Kaczynski and law enforcement. But he's basically feeding them to the wolves, and he's telling and directing Brendan on what to say, what to do. He's getting an investigator involved, which is O'Kelly, and O'Kelly, yeah, I mean, he's taken Brendan stuck to the original story that he said, which he didn't have a clue as to what was going on. There was no murder, and all he did was play video games and that bit about the mail. But I mean, Teresa wasn't involved in this murder scheme,
Yeah.
But when he sticks to that original story and he gives that statement on paper, he is told by O'Kelly to, I mean, that's not going to be any good. And he says that if you want to stick to that, I can't help you out. There's nothing we can do for you, and basically says that he has to write a new one and tells him what to write. He takes the old statement and he basically throws it away, crinkles it up, and he is literally standing there directing this child on what to say, what to write, what to draw, and it's disgusting.
Yeah, that is not adequate representation in any size, shape, or form. So when you get into a trial, there's a couple of things that sort of stand out that need to be looked at, and that is reasonable doubt. And that is the highest standard of proof used in a criminal trial and is required under the Due Process Clause of the Fifth Amendment of the US Constitution. This concept is based on the societal value that it is worse to falsely convict an innocent person than to let a guilty person go free. The issue here is that we can't just convict a person on speculation or just because we may think or believe that he or she may be guilty. Now, you've only got to look at one element of Stephen Avery's trial here, and this is Stephen Avery testified Teresa was at his house between 2 and 2:30. Joellen Zipperer testified she was at the Zipperer house between 3 and 3:30. So straight away, according to that timeline, Stephen Avery couldn't have carried this out in the manner that the state is saying, because she clearly left the Avery property and was seen happy and healthy at another property. But none of that mattered. None of that was brought up. None of that was looked at, just because people thought that Stephen was guilty because they think he's the type.
Yep.
Is there any?
You want me to continue?
Yeah. Have you got anything more on this one, or?
No, I was just going to continue with the reasonable doubt, the difference between reasonable doubt and beyond. Yeah. So reasonable doubt is only applicable if the issuing of a verdict, not in the submission of evidence. If evidence is to be excluded from the case, the opposing side must only present evidence. Why the disputed evidence should be admitted, upon which the judge will decide whether or not to exclude it based on the evidence presented. If evidence is destroyed, fabricated, or altered, or planted and covered up, it would be an act of malicious intent and reason. Therefore, a member of the jury, if not all, should come to the conclusion that reasonable doubt may exist, or exist within a reasonable degree of certainty, or within a reasonable degree of logic. If evidence is missing, excluded, or destroyed within the case, there should be a question as to why such evidence was excluded or destroyed to begin with. Was there some type of malicious intent here? Is the state or law enforcement covering up something that would prove the innocence of the defendant? As a defendant, they should have the right to any and all evidence used against them in a court of law, even if any exculpatory evidence and information that may have been used to exculpate him or her, as all evidence should at least hold some type of exculpatory value, and that a defendant has a right to or should have access to any and all evidence used against him in a court of law. The destruction of biological exculpatory evidence alone brings doubt. Any withheld or hidden exculpatory evidence or information prior to trial that should have been made available and turned over to the defense should show cause for concern and establish a clause for reasonable doubt. So why is this important in Stephen's trial? Why is that important?
I'm just thinking here it's because of the bones specifically, and the bones being given back.
Well, I mean, there's so much more exculpatory evidence out there that wasn't turned over to the defense. besides just the bones. You know what I mean? There's also,
Yeah, I mean,
also
you
biological
know,
material.
diverting from the topic of the German, in just the other main players that everybody knows about, you've got Ryan Hillegas being in possession of the day planner. You've got the DASI PC searches that had been hidden. Then you've got the bones being given back. This is all falling into exactly what you've been talking about. But when we really get into the case with the German, you'll start to see why all of this is incredibly relevant.
Absolutely.
And then we've got beyond a reasonable doubt. That references the standard that prosecutors must meet in order to convict a defendant of a crime. In order to overcome the presumption of innocence until proven guilty in a court of law, prosecutors must be able to show that no other logical explanation can be gained from the fact except that the accused persons committed the crime in question. If a judge or jury have no doubt in their minds that the defendant did indeed commit the crime, or if their only doubts are unreasonable, the prosecutor will have therefore proven the defendant's guilt beyond a reasonable doubt. This is going to become very, very relevant, I think, because the information that we're going to be giving you about the German, I want everybody to stop and think about what this would have meant in regards to beyond a reasonable doubt in Stephen's trial. If all the information that we're going to give to you coming up soon was made available to Buting and Strang at trial, what impact, Ben, do you think this would have had on Stephen's trial?
An atomic impact. I mean, if this was available, it'd be a whole new ball game.
Yeah,
It'd be a different outcome, definitely. He definitely wouldn't have been convicted. I know that.
They wouldn't have been able to fulfill beyond a reasonable doubt. In my mind, they couldn't even have come close to it. So, now that you know why this is all so important, what if we told you there was another suspect? What if we told you there was another Denny? And what if we told you that a district attorney and prosecutor said this subject was, and I'm going to quote here, almost certainly the killer? Ben, do you want to talk some more about what's coming up?
Yes, we're going to be getting into Michael Griesbach, and we're going to be getting into a couple named the Bergs, which are the Germans, and how they are connected to each other and connected to the Avery case.
Yes. Now, there's Michael Griesbach. He genuinely describes Siegfried Berg. I think the line that he says is, if Eva is telling the truth, then Siegfried is almost certainly the killer. Now, all the evidence for Michael Griesbach to have made that statement was available at the time of Stephen's trial. There was evidence pointing quite significantly to someone else. And Ben, this project has been what, about a year in the making?
Over a year.
Yeah.
Definitely over a year. We've had I mean most people that have tried coming down this road or traveling down this road have always come to a dead end. And I did actually come to that dead end roughly probably about like 8 months ago, and that's when I asked you if you wouldn't mind joining me. And it's definitely been a journey.
Yes, it has. We've had some quite hair-raising moments. It's about to get real, I think. As I said right back at the start, I don't think anybody has covered this topic in the way that we're doing it and to the extent that we've done it. I think we've made a lot more links than other people have. We've gone further than most people have regarding this topic.
Well, put it this way, we're still continuing to make links because we just linked to other people into this that we didn't have before.
Yeah, we were.
One of them, I'll just mention his name now, is Larry Levita.
Yes. This topic is just a gift that keeps on giving. And so many times we've reached the point of saying, okay, we've done as much as we can do. We've exhausted it all. And this is the evidence that we've got. And then something new pops up.
So you not only have Michael Griesbach having firsthand knowledge of the existence of said information and evidence, you not only have law enforcement from Manitowoc having knowledge of this, and the state's expert witness also involved in Avery's case also had this information prior to Avery's trial. And these people are not speaking up.
Yeah.
They suppressed this and hid it.
Yeah.
From the
this
defense.
was completely
Possibly.
This was completely hidden. This didn't even make what I've lovingly dubbed the crazy file, which is where they get like the psychics phoning in and they get like the reports about cows behaving weirdly, and they put all those into their own separate, I just call it the crazy file. And the information from Eva didn't even make that crazy file. This information was kept all in-house at Manitowoc. It doesn't appear in their investigative report in any size, shape or form. It was never passed on to Calumet to go in case so. This was kept in-house at Manitowoc Police Department.
No, not police department. Manitowoc Police Department is separate from the sheriff's office.
Okay, it was in the sheriff's office. Okay. Yep. It was all kept within Manitowoc, and it was done deliberately with a motive, and that motive was get Stephen Avery.
Yeah. It is it's definitely appalling, disgusting, and it's really turned my stomach.
Yeah.
To see how all these people can work together against one person like this.
They've deliberately turned a blind eye. Deliberately.
And the way that they did it, it is just, oh man, it's malicious. If anything, it proves bad faith.
Yes, it does. Bad faith and malicious intent, and a lot of it. So we've brought you up to speed with what Youngblood, Brady, and Denny is. Buckle in for the next one, I think.
Yep. Stay safe. Support each other. Respect each other. And thank you.